In 1985, 30 years ago, the Supreme Judicial Court decided an auto insurance case. The case is known as Carden versus Royal Insurance. And in it, the Supreme Judicial Court used a sentence that I can quite never forget. And the court said, navigating the tortuous twists of automobile insurance law is at least as difficult as the uninitiated driver's first foray into the streets of Boston. I think that's an accurate statement because understanding and appreciating all the nuances of automobile insurance law in Massachusetts is a very difficult task. And in a seemingly straightforward situation, many different auto insurers can be implicated. Let me give you a recent example. If a client is, say, a passenger in a friend's car, and that car is struck by another vehicle, and the other vehicle turns out to be stolen, what insurance companies do we look for? Well, the car in which the client is riding provides PIP benefits, PIP benefits, also known as personal injury protection benefits. And they pay, up to a limit, 3/4 of lost wages, and they pay for medical treatment which is not covered by one's health insurer after they've paid out $2,000 in medical treatment. So that is insurer number one who has to be notified, the car in which the client was riding. But I posited a scenario where the offending vehicle, the so-called tortfeasor's vehicle, the negligent party's vehicle, is uninsured because it is stolen. Well, to ascertain that, you would still attempt to notify the insurance, if any, on that vehicle. If none comes forward, or if there is a denial in coverage because the vehicle, say, was stolen, then you have to look to cars in the client's household to cover the client's pain and suffering. Now, that is a provision that came into effect over 25 years ago, and that provision says that if you are struck by an auto that is uninsured, you must turn to the vehicles in your household. If there are two such vehicles, you would make a claim, pro rata claim, on each vehicle. But that would be different from the vehicle in which the client was riding. However, if the client has no cars in his or her household, you would get that coverage for pain and suffering from the car in which the client is riding. The effect of this kind of hypothetical is to show you that potentially 4 insurers could be involved. The insurer on the car in which the client was riding, for PIP. Secondly, an insurer who may decline coverage on an offending vehicle that was, say, stolen or hit and run. And coverages or insurers number 3 and 4 would be providing uninsured coverage on the household vehicles of the client. I think I'll conclude by saying, yes, it's true. Navigating the tortuous twists of auto insurance law is indeed difficult in Massachusetts. Thank you.